An appeals court has reduced the amount of money former President Donald Trump needs to put forward if he wants to fight the ruling in his New York civil fraud trial. Monday's decision reduces the bond from more than $450 million to $175 million. It also gives the former president 10 extra days to find the cash. Let's bring in CBS News legal contributor and Loyola Law School professor Jessica Levinson. Jessica, what is the point of these kinds of bonds, and why would the court reduce it down to $175 million?
Well, this is actually, I think, a rational decision in the sense that what the court's saying here isn't that the penalty that the trial court Judge Engoron, imposed is irrational or problematic, just that Trump doesn't have to pay all of it while he's appealing and saying, that's not how much money I owe, in part because Trump's argument was, I don't have that liquid, so potentially he would have to start selling properties. That, he would argue, would be an irreparable harm. And he's saying, look, if I don't end up having to pay all of that money, why not just make me pay this smaller amount up front, make sure that I'm still paying something in good faith, and then let the appeals process play out?
And so let's assume he pays this reduced bond. Would that take the issue of seizing assets off the table?
For now. And then we wait for the appellate court to say, thumbs up or thumbs down when it comes to what the trial court judge said here, both with respect to liability and the amount of damages. I do, again, think it's important for people to understand this is just temporary. It's just the appellate court saying, while you are in front of us arguing your case, you don't have to put forward the full amount of damages that the trial court judge said that you owe. He could still end up owing that amount of money. This is just a reprieve.
Okay, now we're going to make a huge turn here and switch gears and mix my metaphor. I want to ask you about the Republicans' effort to impeach President Biden, which hasn't gone anywhere. So the chair of the House Government Oversight Committee says he might refer this criminally to the Justice Department instead of using impeachment. Is that legally possible? Isn't impeachment there for a reason with presidents?
Impeachment is absolutely there for a reason. As you know very well, there is an Office of Legal Counsel memorandum from the Department of Justice says that we don't indict sitting presidents. And so you can make all of the criminal referrals that you want, but as long as President Biden is still president, there will be no criminal case that's brought against him. One other thing to remember, of course, is that we haven't seen any specific criminal codes that have been pointed out or highlighted by those investigating the president that could potentially have been violated here. You asked me about the purpose of impeachment. Of course, that's a different purpose. I mean, think about back to what those who drafted the Constitution said about impeachment really being there to protect the government. It's a safety valve to make sure that public men, and this is how we describe people, that public men who engage in public crimes don't get to continue to serve us. It's a way of making sure that we're protecting self-governance.
And let me go back to the Department of Justice, the Office of Legal Counsel ruling on criminal referrals or about presidents. Isn't one of the theories that if Donald Trump gets reelected, that he will then be president and these ongoing criminal cases, not the ones being handled by the Department of Justice special prosecutor, but ongoing criminal cases in New York and in Georgia, what would happen to them based on that Office of Legal Counsel ruling?
This is a great question. And so very broadly, I would say if Trump becomes president again, he will argue that it's not just the federal cases, it's also the state cases that cannot move forward, in part because of what you pointed to, and that Office of Legal Counsel memo, and the idea that there's something special about presidents. You've written and thought about this a lot. And it's not just that we don't want them to sit there as criminal defendants when they should be running the country, but in the cases pending in Georgia and New York, it's the idea that states as separate sovereigns shouldn't be able to reach out and prosecute or continue to prosecute the head of the executive branch. So instead of a kind of horizontal separation of powers argument that you might have with respect to a federal case, this would be more of a vertical separation of powers. States don't reach up to the head of one of the federal branches and subject him to a criminal trial while he is in fact doing what the Constitution says he has to, which is take care to faithfully execute the laws.
So just very briefly, on the one hand, you have the House Republicans talking about criminal referrals, even though they know there's an Office of Legal Counsel ruling that means they won't be heard. And while at the same time you have the Republican nominee relying on that Office of Legal Counsel, essentially, with respect to his possible presidency and any cases. It seems that these are in conflict.
It does. And let's also remember that this is a likely nominee for the Republican to be the president, who also relied on that Office of Legal Counsel memo, I would say quite heavily when he was president. So, yes, I mean, it will shock nobody to know that when it comes to politics, we tend to feel really strongly about making sure that a sitting president cannot be indicted if that's the president who represents our party, and maybe not quite as strongly if that's the president who represents the other party in power.
Jessica Levinson straightening it out for us once again. Thanks so much, Jessica.